Colorado Court of Appeals now in
Good morning, everybody. Please be seated. Welcome to Division 1 of the Court of Appeals. We have two oral arguments scheduled for 9 this morning and a third one scheduled for a little after 10. The first one is People versus Loop. Is that how you pronounce it, Mr. Fredrickson? Lupe, okay. And so I see counsel are ready for that, so we'll hear oral argument first. In that case, and the second one is People v. Johnson. Are counsel here for that case? Oh, thank you. And as you know, for the Johnson case, we have allocated 20 minutes for each side for the oral arguments. As you know, we have our traditional color-coded timers, so you can regulate your time that start green and turn to amber when you have 5 minutes left and red when your time is up. We also have a digital timer so you can regulate your time and allocate time for a rebuttal argument. But if you'd like me to remind you at a specific point on your rebuttal arguments, just let me know and I'll try to do that. You may wish to focus your arguments on the legal issues rather than the facts, because we've had an opportunity to read the briefs and review the record. You should also know that we're live streaming the oral arguments and they're later archived, so if you have any any information that's confidential, please be careful as to how you refer to it during your argument. You should also know that we have a toggle switch on the podium that you can raise and lower to suit your convenience. And finally, I would ask everybody in the courtroom that if you have a cell phone, to make sure it's turned off so it doesn't inadvertently interrupt us during the oral arguments. With that, we're ready to go in the oral argument in People v. Lupe.
Good morning. May it please the court. My name is Matthew Fredrickson, registration number 47453, and I represent appellant Mr. Michael Lupe. Mr. Lupe strictly complied with the requirements of 16-14-102. The court failed to resolve his case in 182 days, and thus it lost jurisdiction. This court should remand with instructions to dismiss the charges in this case. 16-14-102 requires that a person or an inmate who is invoking the protections of the UMDDA, or the Uniform Mandatory Disposition of Detainers Act, simply put his request in writing addressed to the court, that is where his charges are brought, and the prosecutor bringing the charges.
Is the question whether there was strict or substantial compliance a question of fact?
That is an interesting question, Your Honor, and I believe that I don't think so. I do not think so. And I would submit to the court that it's not a question of fact because, well, that's a very interesting question. I would submit no, because the requirements are so plain in the statute. But to the extent it is, this record clearly supports that he strictly complied with the requirements. And the court was clearly erroneous on this record.
What does addressed to the prosecutor in court mean?
That's a good question, too. McKimmey acknowledges the fact that the statute does not define it. And so we're looking at kind of an amorphous idea of what addressed is. McKimmey said, you know, there's really no definition for that, and address can mean any number of things. It doesn't delineate an actual address to that court and that prosecutor.
But doesn't it need to at least be written dear court or to the court, or somehow addressed to those two entities rather than the warden himself?
I would agree with that, but Mr. Lupe did that. Here, when you're looking at page 164 of the court file, he says, Superintendent, send this to the court and the prosecutor. I think that is that to bring to the attention of these people. We see that it would be actual substantial compliance if he sent it to these people directly, so that would undermine any notion that an actual address is required, but the bring to the attention of, that send to these people, is that addressing to these people, but it would be substantial compliance, like in McKimmey, if he in fact sent it to these people.
Isn't it more likely that saying to the warden is addressing it to the warden and then asking him to forward it, as opposed to saying to the court and to the DA, here, warden, please give these to the people to whom they are addressed. He addressed it to the warden, didn't he?
Your Honor, I think that the statute is very that would confuse the reading of the statute. When 16-14-102 asks you to address it to the court and the prosecutor, but send it to the superintendent, he is clearly sending it to the superintendent in this case and then addressing it to the attention of the court and the prosecutor. It's two different levels, and that's why we can't read into the statute a requirement that there be an actual address
Mr.
provided.
Frederickson, if the statute is unclear, how can we even tell if there's been strict compliance with it?
Well, because of what the case law has interpreted what strict and substantial compliance is. Strict compliance is essentially what the statute requires: a written notice addressed to these two entities, and that's exactly what Mr. Lupe did. So I would submit, right, the legislature has not defined these terms, but McKimmey said, you know, it doesn't really need to. When you read McKimmey and Troncoso and Martin all in unison together, the small things, the parsing out, the splitting of hairs between an actual address isn't necessary for Mr. Lupe to actually be able to invoke these rights.
If it is a question of fact, isn't there record evidence that requires us to uphold the trial court's finding that there was not strict compliance?
No, Your Honor, and that is because under the statute and what the statute delineates, Mr. Lupe clearly strictly complied, and so it would be
Even after
erroneous.
what Judge Tao just pointed out?
Well, Judge Tao pointed out that there was no physical address provided
That's not what
for
I'm
the
saying.
prosecutor. I
Let me be
apologize.
clear. I don't disagree that the use of an address has been established, I think, by case law, that's not necessary. But if I say to Mr. Frederickson, I've addressed something to Mr. Frederickson. If I say to Mr. Frederickson, please tell Judge Berger X, I have not addressed anything to Judge Berger. I have asked you to address something to Judge Berger, or at least to deliver a message to him. But when I say to the warden, my thought and my view is, or my concern is, isn't that being addressed to the wrong individual from a strict compliance standpoint? And I guess the secondary question to that is, following up on Judge Berger's question, you've now said at least 4 times that the statute is unclear and that the statute is clear. So which one is it?
That's a good question. So I guess the reason why it's both clear and unclear is on these facts, Mr. Lupe did what the statute requires. So Mr. Lupe clearly complied with the statute. Now there is no definition written into this statute, so for that reason it's unclear. But I do disagree with your point that if you tell me to tell Judge Berger something, that it's not addressing it to Judge Berger. We have other areas in our statutory scheme that talk about directing something to someone through another person is going to be directing it or addressing it to that person. Think about protection order laws, where you can't ask someone to be your agent to essentially violate a protection order, because that would be addressing it to that person. And that would be a violation of protection order. So how then in this instance can that not suffice? And because the statute writes into it this requirement that you send it to the superintendent, how then can it not be the case when you have to send it to someone? It would be substantial compliance if you hadn't, but then you direct it to the attention of someone else. I think that is, under how the statute is currently written, the clear application of the statute for Mr. Lupe's strict compliance, the strict compliance that Mr. Lupe is held to. But as for the lack of definition as to what address and send mean, yes, the legislature hasn't given us direction, but based on the common usage of those terms, then Mr. Lupe has strictly complied with the statute.
Do you contest that the prosecutor did not receive actual notice of the UMDDA request before it accepted Mr. Lupe's plea?
Yes, we can see that the prosecutor did not receive actual notice as defined by McKimmey, but if the court reads Troncoso, the Troncoso case talks about the fact that they would have received actual notice had the superintendent done its job and followed through on its duties under 16-14-103.
So following that through, if there was only substantial compliance, and given your acknowledgement that the DA, neither the DA nor the court had notice before the acceptance of the plea, you lose, don't you?
No, because of Trancoso. Because Trancoso said that they would have received notice but for the superintendent's failures on their duties. And for that reason, the prosecutor and the court would have received notice, which is required under substantial compliance. And that Trancoso case is so important here because it acknowledges that, yes, in that case, the prosecutor and court did not receive notice, but they would have, but for a failure of someone else, so it can't inure to the detriment of Mr. Lupe, or in that case, Mr. Trancoso.
Doesn't that write out the actual notice requirement?
Your Honor, I do not believe so, because you can think of it kind of as a Venn diagram, and that's the way I've been trying to think of how Martin, Trancoso, and McKimmey all work together, is there are ways to substantially comply that don't involve a failure of the superintendent, and that could be like in the McKimmey case where the inmate just sends it directly to the court and the prosecutor. That would be one form of actual notice that doesn't require also this discussion or analysis of what the superintendent was required to do. And Trancoso is that case in the middle of that Venn diagram there, where it's both a failure of the superintendent and a failure to provide that actual notice, but because Mr. Lupe did everything the statute requires, he's entitled to its protections. And so I know where this court is grappling with that kind of that intersection there between where the statute is unclear and where the statute is clear. I don't think it inures to Mr. Lupe's detriment when the statute says put it in writing and address it, does not define address, and give it to the superintendent of the prison where you're currently being housed. And Mr. Lupe did that. And so he strictly complied with what the statute as written requires. Yes, the statute may be unclear for some of our more specific purposes as to what address means, what address doesn't mean. But I would also bring to the court's attention the fact that McKimmey dealt with that very issue back in 2014, and this legislature has had 5 years to kind of deal with the McKimmey opinion and hasn't defined addressed, right? It has not updated the statute. It hasn't dealt with that. So perhaps it wanted to leave it a vague, bring to the attention that I think the McKimmey court kind of held. And the Trancoso case, where inmates don't have access to computers, don't have access to find the specific addresses, is appropriate, is necessary, is okay to strictly comply with what the legislature has condoned essentially over the last 5 years of not changing the law.
If an inmate in the Department of Corrections wants to send a letter, say to a family member, they just write the letter and then put it in the mail, correct?
My understanding is usually they will know the address in those cases.
I'm not talking about the street address. That's a red herring. I'm talking about the process. So don't they just need to write a letter, dear court and dear DA, and then through a kite or some other process, get it into the warden's hands and say, I need you to get this to the court?
I think that would be strict compliance, yes.
But instead, he says, dear warden, please take the extra step. He directs it to the warden, not to the court. So if it's substantial compliance, then the case law requires actual notice, correct?
Yes, if it's substantial compliance, it requires actual notice, actual knowledge. But again, I would return the court to Trancoso, which found substantial compliance and said, everyone would have received notice had the superintendent done his or her job. And I would disagree with the initial point that Mr. Lupe didn't comply with the statute because of that semantic, or that technicality, which was to the warden, bring to the attention of these people. That feels like that is similarly a red herring. With that, I do believe that Mr. Lupe, having put this in writing and directed it to the prosecutor and the court where the specific charge was brought, strictly complied with the statute. In the alternative, he substantially complied, and because it was the superintendent's failure to complete his duties, it just should not inure to Mr. Lupe's benefit, and because the court bypassed or went past the 182 days, it lost jurisdiction and could not hold Mr. Lupe for these charges.
I have one other question.
Please.
The district court said that Mr. Lupe, I'm quoting, Mr. Lupe is using the UMDDA to get his charges dismissed and not tried, particularly when the court had no notice after several appearances that he had filed any request for mandatory disposition of detainer. That's almost the identical language the Supreme Court used in McKimmey to condemn the request by Mr. McKimmey. Why doesn't your client deserve the same disposition?
Because he strictly complied, and because invocation, which is what's required under McKimmey, when it's just strict compliance, like Mr. Lupe did, you can invoke it without the person who needs to protect that right knowing it. And I draw the court's attention to, for example, when you're with a police officer and you invoke your right to an attorney, the attorney you're eventually going to get doesn't hear you invoking your right and isn't able to swoop in, but the person who's responsible for making sure that right is affected, certainly that sets in motion that person's rights. And so I do think that Mr. Lupe, under the strict compliance, and specifically the language of McKimmey that delineates strict compliance and substantial compliance plus actual notice or an actual notice, shows that the invocation is the operative act here. And the fact that he invoked it, much like someone asking for an attorney, is what is the operative act to invoke the protection of the statute. With that, I would request the remainder of my time for rebuttal and ask this court to remand with directions.
Thank you, Mr. Frederickson.
May it please the court, my name is Brock Swanson, attorney registration number 39116, and I represent the people of the state of Colorado in this case. I'd like to start with a quote from the Supreme Court in McKimmey about the UMDDA, and that is, "At its core, the act equips prisoners with a shield to protect them from being confined in jail indefinitely while awaiting trial. It does not arm them with a sword that they can wield to escape trial altogether." So the UMDDA must not be interpreted or applied in any way that would encourage or condone defendants attempting to use a UMDDA request to get charges dismissed rather than to get them tried.
And yet, since it's written in jurisdictional language, it's fairly well understood that's going to happen sometimes, correct?
That's right. And here the defendant contends that under the UMDDA, the trial court lacked jurisdiction to accept his guilty plea. But under the plain language of the statute, that jurisdictional time limit for trying a defendant does not begin, even if the defendant strictly complies, until a request is received by both the trial court and the prosecution. And the defendant suggests that two cases say otherwise, but they don't. McKimmey imposed an additional requirement for defendants who do not strictly comply with the UMDDA, actual knowledge, but it did not dispense with the receipt requirement in strict compliance cases. Rather, it states at paragraph 22, once the trial court and the prosecution receive such a request, the prisoner must be brought to trial on the relevant charge within 182 days.
So, Mr. Swanson, so I'm now thoroughly confused about how the statute works or is supposed to work.
Okay.
So what happens if an inmate sends a letter to the superintendent of the prison and the superintendent doesn't forward it to the prosecutor or the trial court?
So there are, I think the source of the confusion, let me know if it's not, is that there are a number of different potential claims that you can make under the UMDDA. And only one of those is a jurisdictional claim. The jurisdictional claim is that once the limitations period was triggered, the amount of time passed, and there are ways that can be told or waived, but if that doesn't happen, once that time period passes, then the trial court loses jurisdiction in that, over the case. There are other claims, like in Trancoso, they address the claim that if you sent a request to the superintendent and they don't forward it, that is its own substantive UMDDA violation claim, but it is not a jurisdictional claim.
So is there a remedy for the superintendent's failure to forward a UMDDA request to the trial court and the prosecutor?
There is.
What is it?
The remedy is that if you timely present that claim, and here my first argument is that as to that claim is that it was waived by the defendant's guilty plea, but then also the trial court rejected it on its merits because it was not prejudicial. But you have a claim, and the court said in Martin and then reaffirmed in Transcoso, you have a claim that they didn't do that, and then you address whether that prejudiced the defendant. And if it prejudiced the defendant, then that can warrant dismissal.
So just as a practical matter then, if an inmate sends a a UMDDA request to the superintendent of a prison, how is the defendant able to learn whether or not the superintendent of the prison has done anything?
Well, he should tell his attorney that he's done it, and then they should inquire of the court and find out if they've received this.
If it's new charges, he may not have an attorney.
He will at some point.
Well-
I mean, I
Okay,
guess-
so,
go
so
ahead.
the Adams County DA's office files charges on an individual who is already sitting in prison on other charges. That person learns of those charges, properly files his request addressed to the court and the DA, hands it to the warden. The warden does nothing.
Okay.
So there remains an active warrant in the Adams County case. Nobody knows that this case is rolling along, including the defendant, correct? He doesn't have an attorney appointed yet.
I mean, you need to have charges brought for the UMDDA to apply. So it doesn't
Right.
apply just on there being an outstanding warrant.
Well, the warrant doesn't exist until the charges exist often, except in some jurisdictions, but, so there's
Yeah,
charges
I'm sorry.
filed.
Sure.
That's my premise. There are
Okay.
charges filed. The individual is sitting in prison. He has requested through the warden, directed to the court and the DA, disposition of his detainer. But the warden does nothing. There will be no appointment of counsel because there's been no first appearance in court.
Listen to this. There will at some point be an appointment of counsel when they're going to be proceeding on the case. And at that point, if all the time has passed, at that point, he can file a motion to dismiss and figure out whether it has been forwarded or not. Does that answer the question? Does that make sense?
Judge Berger's question.
Sure.
Let me ask you this, are McKimmey and Trancoso inconsistent in any respect that's material to this case?
I don't think so. I'd say no. I don't mean to ask any questions. Do you have any specific area where you're
Well,
concerned?
regarding the necessity when there's strict compliance with the UMDDA of notice to the court and the DA, you don't think Trancoso says anything different than McKimmey?
That is correct. I believe that if you strictly comply, the jurisdictional time limit still does not begin until the request is received by the trial court and the prosecution. And if there's substantial compliance, then it needs to be not only received, but there also needs to be this actual knowledge.
So you're leaving open the possibility that the letter is sent to the DA. They can show that it went in the mail to the DA, but the DA says it got rerouted to the wrong person. I never actually saw it, or the court never got it in the right file because of some paperwork snafu. That's the difference between receipt and actual notice in your mind?
That's right. That's what they discussed in McKimmey, was that it had actually been in the trial court's file and in the prosecution's file, but they had not actually noticed it because it was a pro se filing. And so the Supreme Court in McKimmey said, in that situation, you have to show that they actually knew about it, not just that they received it, because it was a substantial compliance. And so
So there's no situation where there's strict compliance with the statute. The warden doesn't send the papers to where they're supposed to be sent, and your position is the 182 days, if that's the time limit, never starts running.
that is correct. The 182 days never starts, so that there is no jurisdictional claim. Now, there is a claim under Martin and Trancoso that is an independent claim, that they say is an independent claim, that the superintendent didn't fulfill his duties to forward this request. And then what that looks like is like in Trancoso and in Martin, what happened was the defendant filed a claim after the 100 or 90 days or whatever the applicable limit was at the time passed, and said, hey, I think my UMDDA rights have been violated here. And then they looked and they said, oh, they never forwarded this request. And they said, but that does not implicate the jurisdictional limitations. But it does give rise to another claim. But it's not a jurisdictional claim, and so the prosecution can show that it's not prejudicial. And if it's not prejudicial, you don't get your charges dismissed, because this is not a jurisdictional claim. There's no hard time limit on the end there.
So, Mr. Swanson, am I understanding you correctly that for there to be strict compliance, then the inmate would have to send the notice to the superintendent of the prison, and as a practical matter, the superintendent would have to send the notice to the DA and the trial court by registered mail, return receipt requested, so that somebody would know for sure that the trial court judge and the DA had actually received the UMDDA notice?
That's correct.
So even though the statute doesn't say any of that, that's what you're...
No, the statute says all of that.
Okay.
The statute says all
Well,
of
it
that.
doesn't say anything about registered mail, return receipt requested, I don't believe, does
I believe it says, here, I'll throw it in there. I think it does. Let's see. Yeah. Any request made pursuant shall be delivered to the superintendent where the prisoner is confined, who shall forthwith, and then A is it has to gather some information that it sends along with it, and 2B is send by registered mail a copy of the request made by the prisoner and a copy of the information certified to both the court and to the prosecuting official.
Oh,
So
okay.
it's those
Well-
requirements that I'm saying.
it? Okay, well, I stand corrected, thank you.
So, and, sorry, just to get back on here. So,
Before
all
you
of
go
this
there-
is to
before
say,
you go there,
sure,
Mr.
sorry.
Swanson, where does this concept of the defendant just trying to manipulate the system come in here? How do we fit that into the analysis that you're describing?
So, sure. So first, sorry, a lot of things at play here, but I don't think it fits into the jurisdictional claim here at all. If that makes sense. And part of that has to do with the fact that I think that it doesn't matter, my position is it doesn't matter whether this was strict or substantial compliance for the jurisdictional claim, because it had to be received in either case for it to happen. But if the court does want to consider substantial compliance, I would agree with the trial court's findings that this was only substantial, not strict compliance. And I think that Trancoso specifically holds that. It says that we hold that Trancoso's listing of the specific courts to which he requested the superintendent forward information constituted substantial compliance, not strict compliance. It was a request like this sent to the district court. So then on the Trancoso claim, which is this non-jurisdictional claim, our first argument is waived by the guilty plea because it's a non-jurisdictional claim that was waived, and we have settled case law saying that those are waived by the guilty plea. And so then you don't get to that either. What the trial court did is it also addressed that claim on its merits and found that the defendant was not prejudiced. And I think it does come into play there. If you were to get to the merits of the Trancoso claim, one of the factors in assessing the prejudice would be whether that this defendant is really trying to get his claim resolved, get his claim tried, or is instead trying to manipulate the system in order to get the cases dismissed. And so that is the context in which the court considered that issue whether he was
I
prejudiced.
just want to make sure I understand. So if there is strict compliance,
Mhm.
whether or not the defendant, let's use the word sandbagged the trial court, doesn't matter. Is that what you're saying?
I think that's correct in the sense that if he strictly complied and they received that, then at that point, the time limit begins and they have that amount of time in order to try the case, or else the jurisdiction is lost by the trial court. I would like to just briefly address the prejudice ruling on that the court made on its merits, and under that, the case is Martin that addresses that, and in that case, they had a situation very similar to this, where the defendant, with the exception that this was not made, the motion was not made after a guilty plea. So we'd argue that that waives it, so you don't get to it. But if you, on the merits, in Martin, it was a request, and it was 6 days afterwards that he was brought to trial. And the 6 days after the time limit would have passed if the request had been forwarded at the same time that it had been given. If you assumed that it was instantaneously forwarded to the people, it'd be 6 days. In this case, it's 12 days. And in Martin, they said that alone, just that it was only 6 days, was sufficient to support the trial court's finding that he was not prejudiced because the delay was so short. Here we have a slightly longer delay of 12 days, but it's not a significantly longer one. And we also have a number of other indications in the record supporting the trial court's finding that he was not prejudiced. We had that he had 4 other pending charges for robbery during that entire delay that would have independently carried the potential for a detainer and these other negative consequences. We have the defense counsel's acknowledgement at sentencing that the delay helped the defendant secure a beneficial plea bargain. We have the defendant personally extending his speedy trial rights and accepting a trial date, which would have been in December if he'd not pled guilty in October. And that, I think, really gets into the idea of whether he was really being prejudiced or he was really trying to get the case tried quickly versus rather trying to get the case dismissed. So, and I see I'm out of time. Thank you.
Thank you, Mr. Swanson.
All right, Your Honors, I will start by acknowledging, or suggesting to the court that to read in a receipt requirement under strict compliance is not what I think McKimmey held. To read into that is specifically against the language that McKimmey said, strict compliance or substantial compliance plus actual notice.
But the statute requires receipt, doesn't it?
It does require a receipt, but through that superintendent, and that's why my second point talks about Troncoso, and the fact that Troncoso is not a prejudice case, is not a violation of 103 case, it is a substantial compliance jurisdictional case. And I specifically cite the court to footnote 10 and 12 of Troncoso, because that's where Troncoso is trying to deal with Martin, because Martin was a purely violation of 103 case. This Troncoso case was a jurisdictional substantial compliance, strict compliance. The Troncoso case does not jump into prejudice. And specifically because the people did not present any evidence on a lack of prejudice in Troncoso, so they don't even reach 103, because it's on the people to prove a lack of prejudice, and that's under Higginbotham when it's extended to Martin in the Martin situation. So I would agree with the Attorney General when he says that this UMDDA gives rise to a number of different claims, but Martin is one claim, Troncoso is a completely separate claim. It does not deal with prejudice. Specifically, it does not deal with 103. It does not deal with Martin and what Martin held. It jumps over Martin in those footnotes.
But the statute says receipt by the court. It does not say receipt by the warden, even though it's understood the warden is to be the first person to receive the document, correct?
Yes, but then it's also the burden is on the people to prove forthwith, and that's under Martin, and whether or not the warden would have sent it forthwith to the court and the prosecutor. Very briefly, the idea of prejudice was not really what the court based it on, and I see I'm out of time, so I will ask that the court rely on Troncoso and reverse and remand with instructions to dismiss the charges in this case. Thank you.
Thank you again, Mr. Frederickson. Mr. Swanson, we very much appreciate your fine arguments this morning. The case will stand submitted and a written opinion will issue in due course. When counsel have removed their papers from the desk, then we'll set up, or counsel can set up for the next oral argument in People v. Johnson. I just want to thank both counsel. As you know, we had scheduled oral argument in this case, even though it had not originally been requested, because we thought it would be helpful to us to enable us to decide this case. We also sent out an order that included specific questions that we'd like you to address during your oral argument, and in order to enable you to do so without rushing, we have allocated 20 minutes for each side for oral argument. So we look forward to the oral arguments. We hope that you will address the questions that we posed, but also you're, of course, free to address any other points that you would like to make during the course of your oral arguments. So with that having been said, let's proceed with the oral argument in People v. Johnson.
May it please the court, my name is Stephen Arvin, registration number 39020, representing Mr. Emil Johnson. I'd like to thank this court for providing the opportunity to speak with you today about this case. And since this court has provided us with questions, I'm just going to go through and do my best to answer those questions in the order in which they were presented. The first question is, was a trial court's advisory ruling warranted under Walder versus United States, or erroneous because it would frustrate the purpose of the exclusionary rule as discussed in James versus Illinois? The ruling was erroneous because it frustrates the purpose of the exclusionary rule. But before I explain why, I think it's important to observe why this case doesn't neatly fit Walder or the tests set forth in James, and why it doesn't include circumstances that trigger the kind of analysis employed in those cases. And that's because both of those cases arise from circumstances where a witness affirmatively misled the jury by making a statement in direct contradiction to what the evidence showed. This is also true of many of the other cases discussed in the briefs, Agnello, Havens, Haas, Harris versus New York, in which the statements are referred to as potentially perjurious. Those circumstances just aren't present here, where the defense was not proposing that anyone testify falsely on Mr. Johnson's behalf. The defense simply wanted to elicit information that was indisputably true, that there was gunshot residue on the hands of the alternate suspect.
But misleading, given the absence of the truthful evidence that it was also found on Mr. Johnson, correct?
It wasn't affirmatively misleading, Your Honor, and I think that is a crucial distinction to make. Because, again, in all the cases in which this test is triggered, this balance between the deterrent purpose of the Fourth Amendment and the truth-seeking function of the jury, in each of those cases, the court addresses an affirmatively misleading statement. I think the fact that the possibility that the omission of the gunshot residue on the alternate suspect's hands could have misled the jury by omission. In other words, not through any sort of affirmative, deceptive statement or presentation of evidence by the defendant, but rather by a simple omission of fact that there was gunshot residue also on Mr. Johnson's hands, simply isn't enough to trigger that test. I think circumstances like these place this case within the framework of a typical suppression case in which evidence is suppressed and the rest of the evidence sort of plays out as it will.
But doesn't your response to Judge Tao's question point up that we're talking about hypothetical things here, because your client elected not to go ahead and present the evidence? And wasn't your client required to do that, and then if he was convicted, then come to us and say, well, here's what actually happened, rather than all this hypothetical stuff about, well, maybe there was misleading stuff, maybe there wasn't? Courts don't usually deal with these kind of hypothetical situations, and I'm just wondering why we should here.
Well, the reason that this is an error that needs to be addressed is because the trial court in its ruling extracted what's referred to in People v. Short, a relatively recent case that I referred to in my briefs. The trial court extracted a price from the defense. In other words, it was clear to the defense that if it admitted this evidence of this gunshot residue in the alternate suspect's hands, that would extract a price from the defense, which would harm the defense severely.
Isn't that a decision that has to be made by the defendant in every single case? For example, the right to testify carries with it the price of exposing your prior felonies to the jury. That's just a strategy decision that has to be made, right?
Well, again, Your Honor, I'd point to People v. Short. That case deals with the rule of completeness, but still the analysis pertains here. In a situation like this where the court is extracting a price for the admission of evidence, then its ruling can be reviewed as error in the appellate courts.
So, Mr. Arvin, let me ask you a more basic question about the Walter and James cases. In both of those cases, the United States Supreme Court wrestled with the tension between the presentation of evidence that had otherwise been excluded under the exclusionary rule and the interest of the court in making sure that that there was a fair trial. And how do you think the tension between those issues applies here?
Well, I think if you look at the case law, particularly James, the answer is clear that the trial court's ruling in this matter was erroneous. And what I mean is that in James, the U.S. Supreme Court balanced those interests, and it did so in the context of a defense witness that had made affirmatively misleading statements, what they're referred to as perjurious in the opinion. Yet the U.S. Supreme Court found that even in that context, that didn't give the prosecution the ability to admit the suppressed evidence, because this wasn't the defendant himself or herself that was making the misleading statement, and because the U.S. Supreme Court was afraid that ruling otherwise could lead to chilling some of the best evidence that the defendant might have in their pocket. Here we have a situation where the defense wasn't even proposing admitting misleading evidence. The defense was proposing admitting evidence that was indisputably credible. So I think if you look at the sort of transgression that the James court dealt with, where we have affirmatively misleading evidence that doesn't allow the admission, affirmatively misleading statement that doesn't allow the admission of suppressed evidence, and here where we have completely credible, valid evidence, I don't see how, in light of James, that it would be permissible under the Fourth Amendment to admit the suppressed evidence.
Did you find any case following James where either a state or federal court analyzed this situation and said that James means what it says? You can't, as a matter of federal constitutional law, go beyond James. Did you find any case that says anything like that?
No, Your Honor. I haven't found a
Or
case
the
of
other
that.
way, where a court said, well, yeah, James is out there, but James is different facts, so we're not bound by James, and we're just going to apply this overarching doctrine of opening the door.
I haven't, Your Honor. And it's possible that I can't say for certain there are any cases addressing this, but it's possible there's a dearth of cases that would sort of talk about the circumstances here, because, again, we just don't have circumstances that trigger that test. I think this is really just a typical suppression case. This is just a case where the law enforcement violated the Fourth Amendment, and the answer to that is just to suppress the evidence that was at issue in that violation. Because we don't have an affirmatively misleading or deceptive statement, I just don't think we even need to get to this balancing test. I think if we do get to that balancing test, the answer is clear that the trial court still erred, but I don't think we even need to get there.
Under Rule 403, a trial court has discretion to prevent the admission of evidence that might mislead the jury, correct?
That's correct.
So if she hadn't said, if you bring this in, they get to bring the suppressed evidence in, and instead just said, you can't bring it in under 403, would that have been challengeable by your client?
Not if, I guess the question is whether or not that was based at all on the defendant's Fourth Amendment right. I mean, it certainly might be an issue under 403, but here, because the trial court clearly framed its ruling in the context of the defendant's Fourth Amendment right, then I think that puts us in this zone where we're talking about it in relation to that right.
But if we can affirm on any ground supported by the record, would we be wrong to say that if all she had to do was say, You're not letting it in regardless because of 403, because it would be unfairly prejudicial to the people's case, because it would so drastically mislead the jury, and there's no way to fix it in light of the fact that the other evidence was suppressed?
Well, the notion that it would mislead the jury rests on the defendant's Fourth Amendment right to have it suppressed. So I guess looking at it from that viewpoint, I don't see how you escape this Fourth Amendment context.
But the Elmar says that the right to present a defense is still subject to the general rules of evidence, including 401 and 403, correct?
That's correct.
So if 403 says unduly misleading evidence can't come in, where's the error here?
Well, I think if we look at the U.S. Supreme Court cases on this, I mean, it's clear that while they don't talk about 403 or opening the door in those cases, I just don't see how in light of those cases you can't conclude that the trial court didn't err. I mean, again, we have a case in James where a defense witness affirmatively misled, arguably lied to the jury, and the U.S. Supreme Court determined that nonetheless, that didn't allow the prosecution to admit the suppressed evidence.
But as
and I
noted
think,
by Judge Berger, that case, the evidence came in. Here, no evidence that was supposed to not come in came in, right? So there's no Fourth Amendment violation, and there's no violation of MAP and its progeny. The evidence was suppressed, correct?
the Fourth Amendment violation comes in because the district court made clear that if the defense admitted certain evidence, it would admit evidence that had been suppressed pursuant to Mr. Johnson's Fourth Amendment rights. That's a Fourth Amendment violation.
Evidence that the court could have just said categorically, it's not coming in. I'll let you bargain. I'll let you trade for, I'll let it come in if you let this other, if I let this other stuff in. But again, she could have just said, it's not coming in, period. And we wouldn't even be here, would we?
Well, if the district court had simply said that, then of course there'd be a different issue. I mean, if the district court had simply said under 403 without any real analysis or reasoning why the evidence couldn't come in, then we'd be here arguing a different issue. You know, the fact is that if once you get into the concept that the trial court was trying to even the playing field, whether it discussed the Fourth Amendment aspect of this or not, the Fourth Amendment is implicated because it concerns evidence that is suppressed under the Fourth Amendment.
It seems to me we're talking about two very different bodies of law. I mean, on the one hand, you have federal constitutional law dealing with the exclusionary rule under the Fourth Amendment. I don't really understand, and this, I guess, maybe a better question to Judge Tao than to you, but I don't really understand how state law principles, whether it be 403 or the state law principle of opening the door, can affect a federal constitutional right. Do you have any view on that?
I think, again, I think to the extent we can find answers for that in the case law, the U.S. Supreme Court case law, and this makes it clear that they cannot swallow the Fourth Amendment right. The concept of opening the door, 403, they can't swallow a defendant's Fourth Amendment right to have illegally seized evidence suppressed.
Wayne Lefebvre suggests in his Crimpro treatise that perhaps there's more leeway here when the evidence was suppressed as a result of a Fourth Amendment violation than as a result of a Fifth Amendment violation. Do you think there's any merit to that?
I'm not familiar with that particular passage, Your Honor, not off the top of my head at least, but no, and again, I point to the U.S. Supreme Court precedent. And I guess I would say to the extent there might be a difference, I don't think that difference excuses the trial court's error here. You know, again, we have this U.S. Supreme Court precedent where in much more egregious circumstances, the U.S. Supreme Court has found that another court erred in allowing the prosecution to introduce suppressed evidence.
But in the James case specifically, it was suppressed because of a Fifth Amendment violation. And if Wayne Lefebvre's suggestion that the Constitution explicitly says you can't use that information, whereas the unlawfully seized evidence is a matter of court-created suppression under MAP and its progeny, is there something different here? Because this wasn't a statement being used against him. It was a piece of evidence.
Well, I think the deterrence analysis in James still applies dead on here, regardless of which constitutional amendment you're looking at. You know, in terms of will this chill the defense, the answer to that is yes. Is there another means of deterring a falsehood from being issued during a trial? The answer to that is yes. James talked about potential perjury charges, and well, this sort of doesn't fit into the slot because there's no notion of admitting false evidence or testimony. If that were the case, then that could be a deterrence for falsehoods being issued in court. I think the trial court's ruling, if it's upheld in this case, also potentially opens up the problem of sort of a tit for tat going on in district courts where evidence is suppressed and the trial court feels like it somehow needs to even the playing field by not allowing the prosecution to admit certain evidence that is otherwise completely proper, or giving the defense the same sort of choice that it gave the defense here. I see I don't have a lot of time left. Does this court have any further questions on this? If not, I'll move on to the other questions. Okay, so regarding the second set of questions, were the statements uttered by Elmo Johnson and overheard by the alternate suspect non-hearsay as admission by a party opponent? The answer to that is yes. They were admissible under CRE 801. Was the statement...
Regardless of the credibility or reliability of the reporting witness, is that right?
Yes. I don't, unfortunately, I believe that's true, that the law is pretty clear that they're admissible regardless. Was the statement, if you hit me again, I'm going to call the police, you said you weren't going to hit me, admissible as evidence of a similar transaction of domestic violence under the domestic violence statute, 18CA0152? Not in the way that I interpret this question. I think to the extent that this was a transaction, it was admissible under the domestic violence statute, but the statement was still hearsay, and the domestic violence statute doesn't address concepts of hearsay. It doesn't supersede the hearsay rule. There's nothing in the statute that indicates that it does that.
Doesn't the context at least allow for the exceptions, perhaps present sense impression or excited utterance?
Well, I think a court could certainly look at those exceptions and see if they apply, yes. The final question, does the domestic violence statute provide a partial exception to the rule against hearsay pursuant to 805 for the alternate suspect's statement to a detective that the victim told her Johnson had threatened to kill her? No, not the way that I interpret this question. Again, the domestic violence statute doesn't address hearsay. There's nothing in the statute that indicates to me that the legislature intended it to supersede the hearsay rules or sort of replace the liability analysis that's performed under the hearsay rules.
Has any case said that the domestic violence statute is a non-hearsay rule as opposed to what I would call a 404B rule?
None that I'm aware of, Your Honor. I would describe the domestic violence statute, a colleague of mine described it very well. The domestic violence statute is a what statute, not a how statute. It pertains to what is admitted, but what can be admitted, but not how that evidence is admitted. In situations like this, we still need to look to the rules of evidence. Does this court have any further questions on that matter? Then I'll reserve the remainder of my time. Oh, I'm sorry.
No, that's it. Thank you very much, Mr. Arvin. You have about a minute and a half left.
Thank you.
Good morning. May it please the court. My name is Megan Rasband, registration number 43136, and I represent, I'm sorry, I'm getting sick, the people of the state of Colorado. I would submit to this court that both Walder and James fit in, or that this case fits into the framework of both Walder and James. And that is because the evidentiary value of the evidence that the defense here was seeking to admit, which was the GSR evidence found on Tony, is only valuable to the defense if the GSR evidence found on the defendant in this case does not come in. And so this is essentially perpetuating a fraud on the jury because it is misleading them, and it is an affirmative action by the defendant to do so.
Ms. Resman, it just seems to me your argument is so broad that if we accept it, that in every case, after all, most of the time when evidence is suppressed, the evidence is often highly reliable, very important evidence, and yet interests other than the truth-finding process have led the U.S. Supreme Court to say, no, that evidence cannot come in. And it just seems to me you're arguing that, well, in every case, a court should look to see how important the evidence is, and if it's really important, then it just trumps the Fourth Amendment. And I don't understand how we can do that as an intermediate state appellate court when the United States Supreme Court has said that's not the law.
My argument's not that broad. Let me try to narrow it a little bit. So the exclusionary rule is a judicially created remedy to remedy a violation of the Fourth Amendment. And the purpose of it is to deter improper police conduct generally, and it requires that the evidence that was illegally obtained to then be suppressed in the prosecution's case in chief. But the policies behind the exclusionary rule are not absolute, and in both Walder and James, the U.S. Supreme Court engaged in a balancing test to determine if the weight of the truth-seeking function of the trial outweighed or didn't outweigh the deterrent effects of excluding the illegally obtained evidence.
But in James, didn't the U.S. Supreme Court very plainly say, but there are limits to whatever balancing there may be, there are limits. And the limit is reached when you go beyond perjurious testimony by the defendant. If it goes beyond that, the Fourth Amendment interests trump, and if that's true, we have to reject your argument.
I do agree that James stands for limiting this exception in some manner. But I don't think James goes as far as to say that there are no other circumstances in which this balancing test comes out in favor of allowing the otherwise suppressed evidence to be admitted at trial. And
But
it's,
in James, if that evidence, the evidence that was not allowed, or that the Supreme Court found was improperly allowed, was at least very arguably perjurious, correct?
I would agree with that, yes.
So in James, the Supreme Court has said, we will accept perjurious testimony because we're going to protect the defendant's rights so much. And you're suggesting that when James will allow perjurious testimony, as long as it's not by the defendant, that we can apply the same rule and come out on the side of the prosecution for truthful evidence, although incomplete. Does
Yes,
that make any sense?
I think so. Tell me if my answer doesn't make sense. I think the difference, or the similarity, rather, is in James, it is a third-party defense witness. The Illinois Supreme Court extended this exception to all defense witnesses. That's not the situation here. Here it is the defendant that is choosing, or ultimately not, but choosing to admit this GSR evidence, knowing that he can then use it as a shield for essentially perjurious testimony, only it's not testimony here. It is false. It's essentially, like I said before.
It's not false. It's truthful
No,
testimony.
yeah, I'm sorry, I didn't mean to interrupt. It is not, it's perpetuating a falsehood on the jury. The jury is not getting a full picture of, I mean, the truth here is that there were multiple witnesses. Everybody that was in that apartment at the time that Danielle, or before Danielle's body was found, was tested for GSR.
But every time there's a suppression order, by definition, the jury is not getting the full picture. That can't be the test.
I agree with that, and I was thinking about this, I know this isn't a Fifth Amendment case, but I was thinking about this in the context of, let's say, a Miranda violation, where the pre-trial litigate a Miranda issue, and the trial court suppresses those statements. It's true that those statements don't come in and the jury doesn't get to hear that, but that is a very different situation than the jury not hearing about those statements in the case in chief. And then let's say the defense gets up in closing argument and says, well, my client never admitted to this, when in fact that's what the defendant did in in his statements that were found to be in violation of Miranda. I think those are two very different things, and I think that this is still consistent with James, and that the situation here would not frustrate the purposes underlying the exclusionary rule. In James, because the exception was so broad, the court noted that it would vastly increase the number of occasions on which such evidence could be used. It would be essentially in any case where the defendant is calling a witness. And that it also would not just deter perjury, but that it would deter defendants from calling any witnesses at all, because they don't know necessarily what a witness is going to get up there and say. The witness may provide perjured testimony, but that's not the defendant himself providing the perjured testimony, and that's where I think the difference is that, again, here it is the defendant that is, while admitting truthful evidence that yes, GSR was found on Tony, it's using it to mislead the jury, because the jury isn't hearing that other witnesses were tested and that other witnesses were also positive for GSR.
But isn't that part of the deterrent nature of the suppression ruling? Officers, you could have gotten a warrant. You didn't get a warrant. And frankly, in this case, the judge, I think, makes it clear, the DAs, you could have argued exigent circumstances, but you didn't. So this evidence is suppressed. You don't get to use it because you went too far. And if that happens to hurt your ability to deflect a defense case, isn't that just part of the deterrent nature of this, of the purpose of the exclusionary rule?
I don't think so when the defense is using the evidence in this way. Like I said, this evidence only has value to the defendant if he can also use it as a shield, and that is what Walter says is exactly what should not happen.
But what happens here at the core, if your argument is accepted, is that police misconduct, police overreach that violated Mr. Johnson's Fourth Amendment rights also takes away his viable alternate suspect defense. So he is punished because the police did something wrong. How is that appropriate?
Well, I disagree that it takes away his viable defense. In my harmless argument, I mean, the trial judge is very clear here that GSR evidence is not all that. It's not conclusive. It doesn't say that Tony fired this gun. It doesn't say that Elmo fired this gun. It simply says that these people were in an environment where a gun had been fired. It doesn't even say that they were there actually when the gun was fired, which we know from the fact that Stephanie also tests positive for GSR, and she's not there until well after the gun was fired. The defense still could and did suggest that Tony committed the murder, and a juror even asked Tony if she committed the murder.
Can I ask you the same question I asked your opponent? Have you found any case after James that does what you're asking us to do?
Not exactly. The cases that I found, I think they were mostly California cases, and I'm sorry I don't have a site to give you, but it's just in the negative treatment of James. It's in the context of a psychologist in a mental health defense who is relying on statements that the defendant made to the psychologist in order to, or I guess it could technically be a psychiatrist, but to the doctor, the doctor then used to form the basis of his opinion, and the court found that the defendant's suppressed statements could be admitted because it could change that doctor's opinion. So it's not physical evidence like this case, but it is different. It is different than the facts, I guess, of James.
Ms. Rasman, does the fact that we're dealing here with physical evidence as opposed to possibly perjurious testimony make a difference here?
Yes and no. It makes a difference. It makes a difference if it's somebody else, if it's not the defendant that is offering the perjurious testimony, because the defendant is not the one that is affirmatively doing something. But where it is the defendant affirmatively doing something, that's where I think the distinction is.
So you keep making that distinction, counsel, but in James, the defendant, through counsel, offered the testimony of his aunt. Here, the defendant, through counsel, would actually recall a prosecution witness by the offer of proof, the CSI tech, to describe the process of GSR testing. How is that different? They're still just the defense calling a witness, not the defendant. And in fact, in this case, it's even further afield, I think, because it's the prosecution's witness they're calling.
But it's the defendant that is calling the witness to admit the evidence.
Which is exactly what happened in James.
Well, but James, it's a third, I mean, I understand what you're saying, that it is in neither situation, it's the defendant testifying. But in James, I guess there, the defendant doesn't, maybe he does, but we don't know if the defendant knows what this third-party witness is going to testify to. And part of the problem in James is that it does undermine the deterrent effect of the exclusionary rule, because then a defendant is always going to be trying to assess what a witness may or may not say, and they may even have done that, and then the witness gets on the stand and then says something that opens the door. To me, that's just very different than the situation here, where yes, the defense is calling a third-party witness to admit this evidence, but it is the defendant admitting the evidence through that witness. That's the only way they can do it at trial.
So what precisely, we have to be concerned about how our decision's going to be applied in future cases. What precisely is the rule that you are asking us to apply to affirm this judgment?
The rule, I guess, would be something to the effect of where the defendant is using a Fourth Amendment violation, is both a sword and a shield. So in a circumstance such as this, where they've gotten the evidence against their client excluded, but then they're also using that to prevent the full truth from being presented to the jury, that has opened the door to that otherwise inadmissible evidence, because it both furthers the truth-seeking process of the trial, and it does not undermine the deterrent effect of the exclusionary rule, as it did not in Walder. Does that make sense?
I understand it. I don't know if it makes sense.
Right,
or not.
right. The court's question seemed to be largely focused, or is focused on whether this would frustrate the purposes of the exclusionary rule. And again, I just want to draw, I guess, the distinction that I keep drawing, that this is not like the testimony of a third-party defense witness. It would not significantly increase the number of occasions on which a prosecutor could use the evidence. The defendant is only opening the door if he is making a calculated effort to mislead or confuse the jury based on his knowledge that a truthful presentation of the evidence would require some reference to the evidence that was suppressed.
But if we were to affirm, isn't there a great likelihood that in every, let's just narrow it to GSR cases, in every GSR case, now the officers have far less of a concern, because if we go too far and take his GSR, all the alternate suspects are going to go away too, so who cares? We'll just go ahead and take it just in case. Isn't there a serious, even a greater risk than in James of undermining the deterrent value?
I don't think so, because that would require the police to predict that multiple witnesses are going to have GSR found on them, and that the defendant is going to later then somehow use that evidence in a situation like this, where they're using the legally obtained evidence from someone else in a way that's going to mislead or confuse the jury.
I think you underestimate the number of times there are multiple positive GSR tests.
think ultimately here, the admission of the suppressed GSR evidence serves the same truth-seeking purpose as allowing suppressed statements to impeach the defendant. It would prevent Johnson from using the illegal method by which evidence in the government's possession was obtained to his own advantage, and then providing himself with a shield against the contradictions of untruths. If the court doesn't have any further questions about that, I'd like to move on to the second set of questions. I agree with counsel that yes, were the statements uttered by Ilmo and overheard by Tony non-hearsay as admission by party opponent, they would be admissible under CRE 801 D2. The court's second question, whether the statement, "If you hit me again, I'm going to call the police," you said you weren't going to hit me, admissible as evidence of a similar transaction of domestic violence under section 18CA0152. The act itself of the defendant hitting Griego is obviously admissible as other act evidence, and other act evidence was litigated and admitted in this case and admitted at trial. But I do think that the statement here is non-hearsay because it's being offered to show the dynamic of this domestic violence relationship.
But before you get there, can you address whether or not the statute sets forth evidentiary rules? In other words, that overcome the normal rule that hearsay, absent an exception, is inadmissible?
I do not think that the statute provides for that. I think that the statute is meant, it favors the admissibility of other act evidence in domestic violence relationships like this one, and the statute sets forth why that is, because it can be helpful and is necessary in some situations in prosecuting a domestic violence offense, but I don't think it provides an exception to the hearsay rule. That being said, I think there are certain situations where statements could still come in, but that's in circumstances where they're non-hearsay. One example of that would be where the act itself is a statement. For example, harassment is a very common domestic violence charge where the act is the statement, as well as what I think I referenced earlier, which is that statements can also be non-hearsay when they're not being admitted for the truth of the matter asserted, but instead to show the domestic violence dynamic, and that's what that statement here, I think, was offered to show.
Yet the bulk of these statements were analyzed by the trial court and offered by the prosecution under the catch-all, which only applies when you're talking about A, hearsay, and B, hearsay that is not subject to any other exception. What are we to do with that if, in fact, most, if not all of these statements could have been analyzed under different rules?
I think ultimately any error would be harmless because the statements would have been admitted under the other hearsay exceptions. The problem with the statement, "If you hit me again, I'm going to call the police. You said you weren't going to hit me," is that we don't have enough information in the record, I think, to determine whether or not another exception would apply, such as excited utterance. Tony just doesn't provide the detail for that.
And that's my question. If the record doesn't support, because of a lack of development, the foundation for one of the other exceptions, but it shouldn't have been analyzed under 8037 because it was more appropriately analyzed under something different, what are we to do with that?
Well, I think the reason that the prosecution sought to admit these statements under 807 is because they could not establish it under those other exceptions. I mean, exceptions that come to mind that I think were mentioned is excited utterance or present sense impression. I think even arguably it could maybe come under a then existing state of mind, but we don't have that information, and Tony was not cooperative. She wasn't cooperative at the motions hearing. She wasn't cooperative really in her interviews with the police, and especially was not cooperative at trial. So the 807 was the only way these statements could come in because the prosecution couldn't establish those other exceptions.
Ms. Rasband, I see your time is up.
Thank you, Your Honors.
Thank you very much. Mr. Arvin, as I mentioned before, you have about a minute and a half.
Regarding the notion that admitting evidence of the gunshot residue on the alternate suspect's hands without admitting the evidence that it was on Mr. Johnson's hands as well, I think it's worth noting that the defense specifically stated to the court that they would not argue in closing that Mr. Johnson did not have gunshot residue on his hands. They would not argue that Mr. Johnson had never been tested. So again, this further goes to the point that the defense was not planning to use this evidence to mislead. I think the extent that a sword and a shield are identified within Fourth Amendment context, the defense was only planning on using this evidence as a shield, not a sword. I did want to make one quick point regarding the notion that the hearsay statements, some of the hearsay statements might be admissible under a domestic violence statute. I would point out that Tony Carruthers' statement to detective that the victim told her Johnson had threatened to kill her, that was not noticed to the court under the domestic violence statute. And the domestic violence statute does require that the prosecution give notice to the court of transactions that it plans to use. And with that, I thank the court for its time. Thank you.
Thank you very much, Mr. Arvin. Ms. Rasband, again, we very much appreciate your arguments this morning, the vigorous arguments that we've experienced in questioning confirm our justification or interest in having oral argument this morning in this case. So we very much appreciate your fine arguments. The case will stand submitted and a written opinion will issue in due course. So I will not review all of our procedures. I'll just remind you that you have 15 minutes in this case, not 20 minutes as in our previous case, which was a departure from our normal procedures. I would also remind you that the oral arguments are live streamed and then archived. And so if you have any confidential information, you should be careful as to how you refer to it during oral argument. And finally, I would note to everybody in the courtroom that if you have a cell phone with you, please make sure that it's turned off so it doesn't interrupt us inadvertently during the oral argument. So with that, we're ready to begin.
May it please the court, Judge Talman, Judge Berger, Judge Tao. My name is Sheila Muir. My registration number is 1508. I represent the appellants, College Pharmacy, and Jerry Gillick, registered pharmacist. Also representing appellant is Diana Schatz, registration 15145. We have briefed 6 issues on appeal, but wish to argue to us what appears to be the 2 most important. Number 1, the Pharmacy Board's failure to provide College Pharmacy and Mr. Gillick with a reasonable opportunity to come into regulatory compliance without discipline, as provided under the APA, the Administrative Procedure Act, at 24-4-1043A. And the second argument, the illegality of disciplinary action taken against both appellants against College upon a 2009 final agency order, which I will refer to as the FAO. We attempt to underscore our special concern with the outcome of these 2 issues. First, the APA's reasonable opportunity to correct violations and comply with licensure obligations. The legislature provided 24-4-1043A to Colorado's regulatory agencies to guide them in distinguishing what conduct to discipline and what conduct to allow to be corrected without discipline. The section is the legislature's intentional determination that correctable violations of lesser import simply should not trigger the limited resources, time, and money of the state to pursue discipline. The section is a statement of the value the legislature has put on encouraging licensee compliance instead of punishment where possible. The Board's 2018 FAO concedes the applicability of 24-4-1043A to this case and concerning the letters of admonition issued to the respondents, appellants. We are not therefore required to respond any further to the newly minted arguments in the answer brief that 24-4-1043A does not apply.
Well, I'd like you to respond to them, actually. We're not bound by concessions on matters of law. If the statute doesn't address the right to cure, where the issue is, and I know it doesn't speak in terms of right to cure, but I think that's a fair synopsis of it, unless essentially there's going to be action taken against the license. It doesn't address it with something as short of that, such as letters of admonition. Why do letters of admonition fall under that statute?
A letter of admonition is, under the definition of the APA of sanction, a limitation on a license. A letter of admonition is a disciplinary action that has the same consequences to a licensee as would any other discipline. That is, use in a later time to aggravate later conduct, the ability, and particularly in this kind of a case where College Pharmacy is licensed in something like 41 states and 11 foreign jurisdictions to do the same kind of business, the ability to take that discipline and apply it in these other jurisdictions. Everything that can happen from the discipline called the letter of admonition can happen happens in the other types. And because it is a sanction, and because it is a limitation for that reason, for instance, again, has to be reported on the health professional profile that everybody has to file as a licensee, has to be reported on a renewal, has to be reported to the insurance companies that one uses to cover malpractice. So a letter of admonition does not have the distinction, because it's not specifically spoken to. It is a sanction, and it is the sanction issue that the right to cure addresses.
The statute doesn't say sanctions, though. It says no revocation, suspension. Okay, so it's not revoking the license, correct?
Correct?
It's not suspending the license.
Correct?
It's not annulling the license.
Correct?
Is it limiting the license?
Yes.
In what way?
It limits the licenses I've just put forward, Judge Tuck.
That it might later result in a limitation, but as of the moment the letters of admonition go out, nothing is different about how they can practice pharmacy, correct?
That's not the case, because it imposes the additional obligations of disclosure and reporting that we've just discussed. The additional application, the amendment of one's health professional profile, a statutory requirement. The requirement to, at the time of renewal, to disclose it. These are limitations that did not exist before the letter of admonition. And in answering the question to any entity, any government, any private third party, are you under disciplinary order from the Board of Pharmacy? The answer has to be yes. That is a limitation.
But they're still licensed.
Yes, but it's a limitation on the license.
How does it impact what they can do as practicing pharmacists?
It is the difference between a clean record and a non-clean record. It is a smudge. It is a scarlet letter, as would be any other discipline. When asking, am I going to hire this particular licensee because they have a completely clean record, be it a lawyer or a pharmacist? And the answer is, no, this guy has a letter of admonition, or this guy has a suspension. When one goes to the website of the Board of Pharmacy and pulls up, search for the licensee, and types in college pharmacy or Jerry Gillick, up comes the disciplinary history and the link to the actual discipline. That is a limitation on the license. It is no longer a clean license. It is I'll have to use the word again, it is a smudged, made imperfect license. After the board's inspection of November, I'm sorry, sir, are we done?
I was going to follow up with one question. You said under the definition of sanction. Is there a definition of letters of admonition in the statute that equates it with a modification or limitation on the license?
The use of the term letter of admonition
Yes.
within sanction? The definition of sanction is, I believe, in 24.4.102. Includes the whole, it's 24.4.102.17. The whole or any part of any agency, prohibition, requirement, limitation, or other condition affecting the freedom of any person, withholding of any relief, imposition of any form of penalty or fine, destruction, taking, seizure, and so on. Yes, I believe it is.
Okay, so letters of admonition is defined as a sanction. I get that, but does anywhere in the statute define that that form of sanction limits or modifies the license itself, as opposed to just has adverse impact?
I believe it is a limitation, as it states, and it's clearly in the statutory language. After the board inspected college in November of 2013, and this pressure violation that is at the heart of this dispute was found, a pressure violation between the pharmacy's anteroom and the general operations area. As soon as that was found by the inspectors, college undertook construction to rectify the problem.
Mr. Mayor, let me ask you one thing that was unclear to me in the record. The inspection found this problem with the pressure of the room, right?
Yes.
And then either before or afterwards, there were plans to do some construction to fix that problem?
Yes.
But
Before.
the construction didn't start until, I think, January or February of 2014.
Correct.
So there was a several-month period between the time the violation was discovered and the time the construction to fix the problem began.
Correct.
Were they operating during that time?
Yes, but they were not doing sterile compounds.
And is that reflected in the record?
They stopped doing the sterile compounds when the construction began in early 2014.
Well, I know that, but I'm worried about the period between when, I think the inspection was it in
It was in November.
November?
But at that time, in that period of time, the sterile products were being quarantined.
So they were making them but not selling them?
They were quarantining them first, and then when the green light went on, they were able to sell them. So that was the step taken then, and then the full step of completely stopping took place. What's important about this, Your Honor, is that in essence, there was a time in which this board granted the reasonable opportunity to comply, and that was the period of time from the inspection until the notice of charges was filed. Inspection took place, the quarantine took place, the construction took place, the completion of the construction took place, and 2 years passed before a notice of charges. Clearly, the opportunity had been given to college to rectify the problem, and it was rectified. This problem has not existed since August of 2014, including multiple inspections that have taken place since. And so what happened in this case is that this statute was followed by the board, and then 2 years later, inexplicably, that following of the statute, they violated the statute themselves. They reneged on their grant of the right to cure for no particular reason. The cure had taken place, and now a violation was being charged even though the cure was over and even though it had followed. I would ask the court to spend particular attention with findings 13 and 14 in the initial agency decision. Those, I would hope you will permit me to read that out because it is so important to our case. The court, the inspector who made this statement and then who testified at hearing, I'll just paraphrase it, I'm running out of time, specifically said, we found no injury. We found no contamination. We found no patient injury. We found no death. We found that this is a well-managed set of protocols and quality assurance provisions. We find that this is a pharmacy that we have no concerns are putting out a defective product. So the first reason for right to cure, that there was danger, did not exist in this case. And the second reason, that there was a willful and deliberate violation because the regulation was in effect, is not before this case because it was never pled in the notice of charges, it was never tried, there was no evidence, there were no findings, there was no conclusion by the ALJ, there was no exception on that issue by the board, and suddenly it popped up for the first time in the ruling in the final agency order, which I believe was clearly violative of the Administrative Procedure Act and the duties of the board under its own Practice Act. So we have no reason in which the right to cure should not have been granted. The right to cure in this case was granted actually and taken away. There's no reason for this to have happened under the law.
Ms. Mayor, what's your response to I think it was the board's determination that the right to cure in the APA does not apply because of the Patient Pharmacy Act?
The board overruled that position. The board overruled the administrative law judge in this case, and the final agency order in this matter was that it did apply, and that issue was not cross-appealed by the board. It is not before this court, in our view. The second issue I'd like to talk about in general is the question of the 2009 FAO. Of course, the board had the authority to impose probation on the former owners of College Pharmacy, but only for a term certain, because under the Practice Act, once the term expired on April 9, 2016, the board's jurisdiction to enforce any breach of the probation expired, principle established years ago in People versus Gore. The probation ended, its enforcement ended. Now, I understand the distinction that the state's trying to draw to skirt that issue by saying, no, we're not trying to enforce the 2009 FAO and punish for that. What we're trying to do is take enforce independently 12-42.51231M,
Ms. Mayor, excuse me, if we agree with you on this point, what do?
You vacate the letters of admonition. You reverse the ruling and vacate the letters of admonition because it's a combined letter of admonition.
Only one of the letter of admonitions based the letter on both violations.
That's correct. You're count one, correct.
So as to the letter of admonition only based on the violation of the rule, I don't understand why that letter, aside from your other arguments, should be disturbed. Do you agree?
I don't understand.
Well, the individual was not subject to the earlier order.
Oh, that's correct. But it is an indivisible whole, that letter of admonition. We don't know what section applies to what, how much is it 50-50, 40-30, or 47, or 40-60, 70-30, what is it? And in those particular situations, the whole thing has to be, if that's the issue, the whole thing would have to be remanded to reconsider whether or not there's any residual left to apply to College Pharmacy. There's no finding on this, count one, and a separate finding on this, count six, in terms of punishment. It's a mash. I have 40 seconds left. I want to be very clear that our remedy sought is that we want and believe that on both counts 1 and 6, the final agency order should be reversed, and an order enter vacating the letters of admonition. I have 20 seconds left if the court will reserve it for me.
That's
would-
fine, Ms. Mayor.
I would appreciate it, and I thank you all for the time you've given us.
Good morning. My name is Eric Maxfield. I'm a First Assistant Attorney General representing the Board of Pharmacy. May it please the Court, the Board seeks that this Court affirm its issuance of letters of admonition against both Jerry Gillick and College Pharmacy. And it does so for 6 independent reasons. The first I'd like to draw your attention to in a reverse order from, yes,
Excuse me, Mr. Maxfield, before you get started addressing those 6 issues, I wanted to ask you why in your brief you disagreed with the appellant's phrasing of their statement of every issue that they raised. If they're the appellants, aren't they entitled to phrase the issues on appeal as they wish to do so?
Your Honor, I reframed the issues and attempted to make that reframing as pure issues of law rather than as argument. But yes, they are entitled to make the issues, frame them as they wish.
Okay, thank you. You may continue with your argument.
Drawing your attention first to what is dispositive and the narrowest, simple approach related to College Pharmacy and the LOA is application of the, or view of the stipulation and final board order from 2009. It was in effect from that period until 2016. It was negotiated between College Pharmacy and the board. It was something that required probation, and as a result, supervision of College Pharmacy explicitly required compliance with board rules. It didn't individuate between types of board rules. It required reporting by the person who ultimately turned out to be, for the entire period, Mr. Gillick as the managing pharmacist.
But I'm reading from the board's letter of June 15, 2016. It specifically says, after due consideration, the board voted to release College Pharmacy from the terms and conditions of the STIP/FAO. Why doesn't that just end it? Why shouldn't we apply the body of authority that has been developed in the probation setting to say, if you didn't institute proceedings under the FAO, you're done. You may have other violations, which you had, or you alleged, but this is done. I don't understand that.
Your Honor, the board had more than one option under the probationary stip. And it had the option to declare the stipulation null and void and seek revocation per the stipulation itself, but inconsistent with criminal law and the application of the cases cited by Ms. Muir concerning criminal probation, the board also has this negotiated stipulation in place between parties in an administrative process where it was in place. And I think the distinction is in the Pharmacy Practice Act, because it's listed as unprofessional conduct to violate a valid board order. Well, that board order was in place at the time of the conduct, or in this case, misconduct. And so the board, rather than take the extraordinary step of declaring the stipulation null and void and seeking revocation, exercised discretion to lift the probation and rather issue an LOA. And after trial and exceptions, it also resulted in a final board order of LOA, letter of admonition, sorry. But that's not for violation of the probation as where the board seeks to enforce the probation. The board is seeking a separate path here, simply to enforce the Pharmacy Practice Act, where one of the grounds for unprofessional conduct is violation of a board order. It was in effect at the time.
Is there any statute of limitations in either the Pharmacy Practice Act or the APA?
There is no statute of limitations.
So is there any explanation in the record or otherwise as to why they waited 2 years after essentially saying, the way you just phrased it is kind of this benevolent, well, we could take your license, but we'll back off, let you off the probation, but we're still going to pursue a lesser sanction. But they didn't even do that. They released them from probation and then 2 years later filed charges, right?
That's correct, Your Honor.
Why the delay?
There's nothing in the record that reflects a reason for the delay. It is important to note, however, that the parties could have affirmatively pled laches but failed to do so. That is certainly a concept that's relevant to the proceedings. And the board could have, at the time of the misconduct, taken urgent action like a suspension. It did not. It exercised its discretion and declined to do so.
If we reject your argument on this part of the case, but reject the other arguments made by the pharmacy, what do we do? What disposition do we reach?
If you reject the arguments on probation, you should turn to the concept of reasonable opportunity to comply and make a determination of whether that provision applies to the Pharmacy Practice Act, and if it does apply, whether an exception comes into play.
No, what I'm saying is, if we say that the board released the pharmacy from this FAO, you acted improperly in bringing charges under the FAO. If we hold that, but reject the remainder of Ms. Mears' arguments, what is the disposition that we should reach?
The disposition should be that you affirm the letter of admonition as reasonable under the law and a reasonable exercise of discretion. Alternatively, if you are dissatisfied with, as counsel for College Pharmacy indicated, it's not apparent a percentage of discretion that was applied or importance between two charges. It could certainly be remanded to the board for further consideration. I'd like to turn from that first issue of the probationary stipulation from 2009 to 2016 to the reasonable opportunity to cure issues. So on those issues, there are 5 separate independent grounds that are potentially dispositive in the board's favor and should not result in a reasonable or any opportunity to comply for College Pharmacy. And indirectly also impact the letter of admonition against Mr. Gillick. First of which is the conflict between the statutes. So I'd like to draw your attention kind of back to a big picture view of that Administrative Procedure Act, reasonable opportunity to comply section, and the Pharmacy Practice Act's procedure in a related sense. So the APA, that provision, asks an agency to look at the gravity of the misconduct that it finds upon a full investigation. And it tells the agency what to do as far as how to consider that gravity. If it determines that there's deliberate and willful misconduct, it shouldn't offer an opportunity to comply. If it determines there's a substantial danger to the public, makes that gravity determination, there won't be a reasonable opportunity to comply.
What about Ms. Mears' argument that there never was pleaded or placed in issue this concept of willful violation?
What was placed in issue by pleadings was the reasonable opportunity to comply section of the APA as an affirmative defense by College Pharmacy and by Mr. Gillick. It was fully litigated. There were findings of fact and conclusions of law in the initial decision and in the final board order. I'd also like, in my big picture assessment of the APA, turn your attention to the Pharmacy Practice Act and note why that supplants that portion of the APA. So the Pharmacy Practice Act directs the board to consider things like dismissal with a confidential letter of concern, where a matter doesn't rise to the level of formal discipline, but it could if it were repeated. It directs it to consider, if not that type of dismissal, whether a letter of admonition should issue, and it even provides further process for how that should happen. So a letter would go out, and if it's not objected to, becomes the final order of the board. If it's objected, the board has an obligation at that point to file a case. Plus, the board is directed, if none of those options apply, to consider things like probation, whether monitoring, restrictions, or suspension or revocation should apply. So all of that type of detail is the same type of detail that's apparent in the Medical Practice Act. It's not identical, but it's very similar. And in the Colorado Medical Board v. Reiner case, that Court of Appeals determined that the Medical Practice Act supplanted that reasonable opportunity to cure provision, and likewise, that should occur here. But I also want to draw your attention to another reason, and that's statutory, just plain language, that was raised by Judge Tao earlier as a question, the letter of admonition concept. So the General Assembly knows how to put in words of inclusion, like they could have said that in the reasonable opportunity to comply portion of the APA, that it's these concepts, but it could includes others, but it didn't do so here. It also defined sanction, a very broad concept that at least arguably includes letters of admonition, and they didn't say this applies to sanctions. So letters of admonition, which are notices to the regulated individual or entity and to the public, were accepted as a consequence. And then I'd also like to draw your attention to further argument of why reasonable opportunity to comply doesn't come into play here, and that is if that provision of the APA applies. There are two exceptions that come into play, and that concept of reasonable also comes into play. They're all interrelated in the way that the facts of this case play out, so I'm going to discuss them together. So the deliberate and willful concept, this was a case where the board was under supervision by virtue of the probation, had agreed to follow all board rules, knew of the requirement, had a malfunctioning pressurization system. The pressurization system was made to address the important role of public protection of moving the particulates, whether it's fungal or bacterial, away from the compounding area out to anteroom and out to the general pharmacy area. The malfunctioning system was between the anteroom and the general pharmacy area. The fix was not made until August, but one thing that happened was it wasn't working at the inspection time in November of 2013. They continued to conduct high-risk compounding until about February of 2014. It was only at that point that they ceased that compounding, and then ultimately in August, the system was fixed. So the rule was known, violated, ongoing, and the conduct that it was designed to protect continued as well. So related to the deliberate and willful exception that stands as an independent exception is the danger to the public exception in the APA. And so those facts about the purpose of the rule carry over to that concept. But also in the record you'll find reference to the potential for harm includes not only contamination but consequences to patients. So that could include bacterial or fungal infections, and as in the by the reported and in the record reference to New England Compounding Center resulted in fungal meningitis that in some cases resulted in death.
Mr. Maxfield, let me ask you about that. The respondents say that exception shouldn't apply because there was no actual harm, whereas you said in your brief that it applies to potential harm as well.
Yes.
Why do you think it applies even if there's just potential harm?
It's a fundamental principle of professional licensure by agencies that they are looking at qualifications and competence of licensees or registrants, and when they hear information that demonstrates a concern about competence or qualifications, they need to take prospective, corrective action, and don't need to wait for a harm to occur. Separate and distinct from our system that permits an individual to go to court to seek to enforce their individual rights to be compensated for personal damages. I also would like to draw the court's attention in my final minute to this concept of right to cure. I believe it's important to note that that's essentially rewrites the statute. The APA says quite a number of things under that provision that says explicitly reasonable opportunity to comply. It has two broad exceptions in it, and in essence asks an agency to assess the magnitude and gravity of the circumstances, doesn't require its application in at least two circumstances, but also in that requires an agency to give a reasonable opportunity to comply. And so in the event that that doesn't occur, the agency shouldn't provide that chance. Thank you for your time today, Your Honor.
Thank you, Mr. Maxfield.
The inspector involved in real time in November of 2013 is the finding that I read to you now. Quote, "There was no evidence of patient harm. There was no evidence that any products produced by college were contaminated. Likewise, there was no evidence that any patients became sick or died. All the board's inspectors who testified unequivocally stated that college had both well-established and well-documented quality control and assurance procedures in place to prevent contamination. The board's inspectors expressed no concerns regarding the safety of products being produced by college pharmacy." To answer your question, Judge Tao, the 2 years indicate, just like the late filing on the 2009 FAO, it's the same thing on count one. It was done.
Ms.
When-
Meir, excuse me, your time is up.
All right, thank you.
Thank you, Ms. Meir. Thank you, Mr. Maxfield. We very much appreciate your arguments this morning. The case will stand submitted, and a written opinion will issue in due course. That concludes Division 1's oral arguments for this morning. The court will be in recess, and the bailiff may so announce.